Welcome back. New York State is the first state to pass a new measure protecting struggling renters since the Supreme Court attempted to rid the existing shields against eviction. Now, New York State lawmakers agreed to an extending sweeping protections against evictions into next year, moving to keep hundreds of thousands of people whose finances have been battered by the effects of COVID-19. And the question is, what does it actually mean moving forward? Sharing more details in this conversation, we're pleased to have with us partner at David A. Gallo Associates LLP, Robert M. Link. And Robert, good to have you again.
Daren, great to be here again. Thanks.
It seems as though we moved the needle a little bit forward again. And as we're looking at this, of course, renters can say, listen, I thank goodness that I have this protection. But really, for a lot of people, landlords included, this becomes a more challenging effort because we know from the outset that people have definitely had questions about those who have not paid rent and the backlog. Talk to us about what this actually means moving forward.
Well, I mean, it's a challenging situation for everyone. It's a challenging situation because we've never been in a situation where we have the economy closed, where we can't be cheek to cheek next to each other. We need to check vaccinations. We need to make sure everybody's safe. So we have these historic measures that are being taken by the legislature, by the courts, in order to keep people safe, to give people an opportunity to pay back those rent arrears. However, this is taking a long time. I started appearing on your show, I think back in May of 2020. At the time, I said, I easily see this moratorium being extended through the end of the year. The last time I was on, I said, I see this moratorium being extended basically for all intents and purposes to June 2022. Now, I think that was a bit of a conservative proclamation. So basically what lawmakers have done is they took the old law that the Supreme Court had a problem with, and they strengthened it. They added due process for the landlord. So if you're a tenant and you say, I'm having a COVID hardship, and you affirmatively submit with the court or to your landlord an attestation saying that you've had a hardship, you're going to be protected. You can breathe a sigh of relief because the landlord cannot move forward with the case. The court will not move forward with the case until January 15th, 2022. So that you breathe a sigh of relief there. Now, the due process aspect that they needed to add as a fix to the concerns raised by the Supreme Court was that the landlord should have an opportunity to challenge the assertion that you're having a COVID-19 related hardship. So if you're the tenant and you say, listen, I don't have anywhere to move, I can't move during COVID, I've had a decrease in income, I've had an increase in expenses, whatever the case may be, the landlord should have an opportunity to challenge that under the new law. But for all intents and purposes, particularly in the city of New York, where they can't handle the calendar that they already have, I don't realistically see those evidentiary hearings, that motion practice kind of coming to fruition. I think the best hope for landlords is that, the federal courts, again, come to their rescue.
I think you leaned into my question I was getting ready to ask you, because we already know there is an existing backlog when it comes to court cases. You can't even get into the court in New York City. A lot of people have been waiting prior to COVID. Given the fact that you've got COVID now and you've got this housing challenge is the best way that I'll say it, and I'm struggling to get in, how do I make it into the court system given the fact that there's this heavy backlog? Are there enough courts to be able to deal with the situation at present?
The answer is no. Daren, you hit the nail right on the head. There were, thousands upon thousands of cases filed in the New York City housing courts from March of 2020 through August of 2021. There were another 66,000 eviction petitions filed in New York City. Of those 66,000, only a small number of those petitions were actually assigned court dates. So in addition, and that's not including the cases where the tenant actually affirmatively filed that hardship declaration. That's overall where probably a majority of them did not file the hardship declaration. So the courts, irrespective, at least in New York City, upstate is a different world, right? Even Long Island is different. But in New York City, even where there is no hardship declaration, the courts don't have enough time and resources to get to the petitions that are already there. So in addition to a moratorium through January 15th for the cases that have filed a hardship declaration, there's kind of a de facto moratorium that I believe is going to extend well into 2022 and maybe even beyond, because at some point, we have to get people back into courtrooms again. Not everybody is equipped to handle remote hearings or even telephone hearings. So you got to give people an opportunity to get into court, have due process, have trials, have inquests. And I really don't see that happening anytime soon. And I don't see us making progress to that point, or even a roadmap. I think there was a meeting with the administrative judge of the Queens County Housing Courts about a week ago, and he said, I got 7,000 petitions that have not been assigned a court date. My staff is going to be looking at it, and we'll be assigning, I don't know, 100, 150 a week for court dates in the future beyond the January 15th, 2022 date. So do the math yourself. You're adding another 6-7 months to the process right there, just because of the backlog. So if you're a landlord, my recommendation, if you have a good tenant, help them apply for the ERAP funds. That's the $3 billion that's been set aside largely by the federal government to help tenants, pay back those arrears, work with them, try to get those funds back and try to settle these cases, because there's no pot of gold at the end of the rainbow. There's no light at the end of this tunnel. It's going to keep going and going and going.
We talk about economic empowerment and really seeing people get back to work after COVID and the ability to get their income and generate their income and get back to a reasonable way of living. But when you talk about the place of landlords, we've always been talking mostly about tenants here. Landlords just seem to be the ones that are suffering. And this is how they make their living, off of tenants, off of rent, getting that income in. But yet and still, for the landlord, with this moratorium, they're the one that seems to be on the backside of it. Now, I know recently we've seen more and more cases of landlords now going to the court, not in defense, but actually suing. Share with us a little bit about the landlords that are actually taking things into their hands.
So if you're a landlord, you have a few options. You can go into civil court or Supreme Court, depending on the amount of money that's owed, and you can get a judgment for the amount owed. You're not going to be able to kick out the tenant. You're not going to be able to evict them and get a judgment of possession against the property, but you are going to get a judgment in court that says this amount of money is owed. Okay. The problem with that is it's kind of a moving goalpost. Every month of rent that's missing, that judgment will continue to increase. The other things that they're doing, a lot of smart landlords are trying to settle these cases and work with their tenants on applying for the ERAP funds to make themselves whole as much as possible. In exchange for taking that money, you are not allowed to evict for the following year. So those are the kinds of options that they're looking at. The other option, of course, is a legal challenge, and I think you've already seen declarations from the landlord lobby, from the Rent Stabilization Association, that they're going to go right back to court and say that this fix is unconstitutional.
Yeah. Well, what can we expect coming up after the ban? Because we've got life after that. The ban will, soon be over. What do we expect after that?
So a couple of things can happen. Remember, January 15th, 2022, that's a few months away. A lot can happen in that time. My guess is a lot of that ERAP funds are going to be gobbled up. One of the primary justifications for the extension was that the Cuomo administration did not successfully roll out this program and get this money flowing to tenants. The incoming governor, Kathy Hochul, has made this a priority. And my understanding, based on landlords I know, is that the money is flowing a little bit more easily, and that this is being made a priority. So that's what we're going to see in the immediate term. We may also see another successful legal challenge. The landlords were successful challenging the prior New York moratorium to the United States Supreme Court. That's obviously a conservative court that might be a little bit more inclined to grant relief to landlords, but we'll see how quickly they can get there. But at some point, from the landlord's perspective, don't you need to draw the line, or can this be extended indefinitely? Again, irrespective of whether or not this moratorium survives, in New York City, there will be a de facto moratorium just by virtue of the fact that we can't cram people into courtrooms like we used to. We aren't going to be able to handle the amount of petitions being filed, the amount of trials. You're going to have new defenses being interposed beginning in 2022 that are challenging the landlord's compliance with this particular administrative order, or the ERAP process, or the moratorium. You're going to see these new legal defenses. They're going to go up to the appellate term. There's going to be new law on how we interpret these hearings. And then you have another weird kind of law. It's RPAPL 733. It essentially requires the landlord has to advise the tenant more than 10 days, no less than 17 days, that the first appearance is coming up. Well, here we have this weird procedural posture where there were cases filed in mid 2020 where they haven't been assigned a first date. So at what point do the landlords serve the tenants with the petition and the notice of petition to let them know that their court date is coming up? And how will they be afforded that opportunity? How will that process play out? I mean, there's a lot of interesting questions. We're in uncharted territory, and it's anybody's guess how long it's going to actually take. But I don't see it happening anytime soon.
And we have this preconceived notion when we talk about going to court that it's going to be a simple one and done. If you're going on that one day, you'll meet the judge, you'll have something determined, and boom, it's all over. But the fact is, that's not always the case. Some of these cases require continuances, and you move on, further elongating, the calendar. From a lawyer's perspective, and how, your front line and your boots on the ground, how have you been able to handle and just navigate this whole process? Because as frustrating as it is for a landlord, as frustrating as it is for a tenant, I'm hearing equally the amount of frustration on the part of legal counsel.
So I represent a lot of small businesses in eviction proceedings, and they all have different priorities. So for example, I have one client who wanted to get into eviction court as soon as possible because they wanted to assert counterclaims about the landlord's failures to make repairs. There was a dispute over the rent, and as a retaliatory measure, the landlord didn't want to maintain the property as they were required to do under the lease. So we had to make a motion in that case to expedite the hearings, even though we had also filed a hardship declaration that said, well, we have this COVID hardship and we should be afforded beyond January of 2022. So, you have different fits for each particular client, and they're going to be unforeseen consequences for clients like that. I mean, I have other clients who are very pragmatic, just wanted to get out of the lease and make a settlement on the arrears. I have clients in long-term leases that, invested a lot of funds into improving a property, or, a residential tenant who, this is my home, I want to be there, for as long as possible. So in every case, you really have to map out the best case scenario, the worst case scenario, and make sure you're getting the result the tenant wants, not just what you think might be the successful result.
Yeah, Robert, we're going to have to continue to follow this out. As always, it continues to evolve, and the more it evolves, of course, the more we bring you back to pretty much break this down for us, as it gets really hard when you start getting into the weeds. Robert M. Link, our guest here on Open. Robert, thanks again, buddy.
Anytime, Darren. Thanks a lot.
All righty. Well, I want to let you know if you want more information, we encourage you visit their website at dagallp.com, dagallp.com. Have more show for you here on Open. Don't go anywhere. Just going to take a quick break, and Open will return right after this.